then.
Sir, namaskar, sir.
Namaskar.
Yeah, I can see Leela ji also.
So I'll take it. A very good afternoon to everyone joining us for the fourth session of day 3 of the International Conference on Mediation 2021. I extend my heartiest greetings and gratitude to all of you for taking out time and being with us through the virtual mode. The session today would be on mediation in commercial disputes. To discuss the different facets of it, we have a stellar list of panelists and esteemed dignitaries. To begin, I would like to introduce our co-chair for this session, Professor Dr. Rajni Abhiman. Ma'am has been teaching in the Faculty of Law, University of Delhi since the year 1991. She has also been the visiting professor for the Beijing Institute of Technology and the Nanjing Institute of Aeronautics and Aerodynamics, Nanjing, China. She's authored more than 10 books on law and more than a dozen articles on various subjects in several law journals. She has been the government nominated director for the Delhi District Cricket Association, DDCA, member, Executive Council, Hemwati Nandan Bahugana University, member, Academic Council, University of Delhi, mayor, MCD, member of the Delhi Jail Board, among a very remarkable list of associations. Ma'am, I would now request you to formally welcome the panelists for the session.
Good afternoon, all the panelists. I welcome all of you to the second International Conference on Mediation. This conference is being held by Law Center 2, University of Delhi, in association with Samadhan, which is the Delhi High Court Mediation Center and Delhi School of Public Policy and Governance under the research project of Department of Justice, Ministry of Law and Justice, Government of India. Today is the third day of this conference. And in these third days, the first day, we had the inaugural session. Yesterday also, we had 2 sessions. Today, it is the 4th session in progress right now. And after this, we have the valedictory session. We are very fortunate to have Justice Vineet Kothari as the chairman of this session. A brief introduction of Dr. Justice Vineet Kothari. He is presently the senior most judge of the Gujarat High Court. He was the senior most judge earlier at Madras High Court and discharged the duty as acting chief justice also there for around 2 months. Initially, he was appointed as the judge in the Rajasthan High Court, and he joined Karnataka High Court upon transfer later on. He was born and brought up in a reputed family at Jodhpur, Rajasthan. Dr. Justice Vineet Kothari accomplished the qualifications of BCom Honours, LLB, LLM, and PhD in tax laws at Jodhpur. Not only legal education, he is a qualified chartered accountant as well as a company secretary. He practiced as a tax and constitution lawyer in Rajasthan High Court after enrollment by Bar Council of Rajasthan. After practicing as a chartered accountant for 2.5 years, he was enrolled as a lawyer since 1984. Justice Vineet Kothari has decided approximately 23,000 cases in Rajasthan High Court, 14,000 cases in Karnataka High Court, and around 8,000 cases in Madras High Court, mostly on civil and tax laws, and a few criminal appeals too. His Lordship has contributed papers for national conferences and international conferences on international taxation and other allied subjects in various European countries at Amsterdam, Helsinki, Switzerland, Brisbane, Australia, and is the honorary director on the board of International Association of Tax Judges and member of CMJA in London. We are very glad and we are honored to have you, sir, as a chairperson for this session in this conference. Next, we have Ms. Leela Olapalli. Ms. Leela Olapalli is the founder of CAMP, that is Arbitration and Mediation Practice Private Limited, a pioneering private mediation initiative set up in 2015 in Bangalore, India. She has practiced as an advocate for over 3 decades in the Supreme Court of India and the High Court and Consumer Courts of Karnataka. Since 2014, she is a full-time mediator. She is the founding coordinator of the Bangalore Mediation Center. uh, court in ex mediation program of the High Court of Karnataka, and one of the leading court in ex mediation programs in the country. She's a senior mediator and master trainer at BMC. She was nominated to the International Who's Who Legal of Commercial Mediation 2019 and as a global leader in mediation for 2020. She's on the advisory board of Global Mediation Panel UNDP. Ms. Leila has been appointed as a member in the uh, board of director of the International Mediation Institute. I'm proud to inform that she's the only Indian on their board. She's on the panel of mediators of the Singapore International Mediation Center and other international and domestic mediation centers. She trains extensively in mediation and negotiation. Ma'am, we are very lucky and honored to have you in this session. Welcome. Next, we have Mr. Tejas Karya, uh, who is also very well known. Mr. Tejas Karya is a partner and head at the arbitration and Shardul at the Shardul Amarchand Mangaldas and Company. He has wide experience in handling international commercial arbitrations across sectors. He has represented multinational and Indian corporations in ad hoc and institutional arbitrations seated in India, London, and Singapore. He regularly sits as an arbitrator. His well regarded contribution to policy formation across the arbitration domain endows him with a deep understanding to present solutions that deliver effective resolutions for his clients. Mr. Tejas has advised on the drafting of the Indian Arbitration and Conciliation Act 1996 and the Commercial Courts, Commercial Division and Commercial Appellate Division of the High Court Bill 2015. He's also been a part of the High Powered Committee for Institutionalization of Arbitration in India. He is a member of both Singapore International Arbitration Center, Court of Arbitration, and the ICC Commission on the Arbitration and ADR. He is a fellow of the Chartered Institute of Arbitrators, London, and director of CLARB, CL Arbitration India. He is a member of Governing Council of Indian Law Society, apart from being the vice chairman of the Society of Construction Law in India and director of Indian Arbitration Forum. He is ranked in Band 2 for arbitration by chambers and partners and recognized as a distinguished lawyer in dispute resolution by Asia Law Profiles. Who's Who Legal? Arbitration lists him as a global leader. Benchmark litigation recognizes him as dispute resolution star, and Legal 500 lists him as leading individual for arbitration. He's also listed among top lawyers in India by Forbes India. Sir, we are really honored to have you. We have one more panelist. I don't think whether she's joined right now or not. Miss Iram Majid. Ms. Iram Majid is the director of Indian Institute of Arbitration and Mediation. She is executive director of Asia Pacific Center for Arbitration and Mediation. She has undergone training for arbitration from Chartered Institution of Arbitration UK and Indian Institute of Arbitration and Mediation, and regarding mediation in many reputable institutions, including the Harvard Law School for Advanced Mediation Program on Negotiation in Harvard Law School, widely considered as the best legal education institution in the world, and Pepperdine University, California. She is co-founder and Secretary General, International Federation of Mediators in France. She is APCAM certified arbitrator and impaneled as arbitrator with all member countries like Hong Kong, Australia, Indonesia, Nepal, Malaysia, and with Thailand arbitration centers, and in India with the Delhi International Arbitration Center mediator with WIPO. She's a mediator, like in Court Annex Mediation Center since 2009, Samadhan, the Mediation and Conciliation Center of the Delhi High Court, Indian Institute of Arbitration and Mediation. She won the BIA MAC Top 10 Mediators in Asia Pacific Awards 2019. She participated in various seminars as delegate and speaker, like the Hong Kong, South Korea, Indonesia, Bangladesh, UAE, France, United States of America, UK, Tanzania, Morocco. Ms. Iram is a member of Thailand Arbitration Center, International Federation of Mediators, HKIAC, Indian Institute of Arbitration and Mediation, UK, Ambassador in International Brazil Arbitration and Mediation Center. Ma'am, we are honored to have you. With such galaxy of speakers, now I hand it over to you, Ankita, to start the proceedings.
Thank you so much, ma'am. With this, I invite Ms. Leila Olipalli, ma'am, who's also a guest of honor for this session, to share her wide and rich experience with us. The virtual floor is yours, ma'am.
Thank you. Thank you for this august team of organizers, students, participants, and to all those who are part of this panel. It's indeed highly prestigious and a great honor for me to be with all of you. So thank you very much. In the few minutes that I have, I'll be answering the question, does mediation work for complex commercial disputes? And as you can guess, my answer unequivocally is yes. It works very well for complex commercial disputes. 2 weeks ago, I was talking to the former CEO of JAMS, one of the oldest and largest private mediation providers in the US. And he told me that over the last 1 year, they mediated more than 17,000 complex commercial disputes, multi-million dollars, complex facts, multi-party, and as they say, almost all of them resolved. I want you to highlight that, almost all of them resolved. Now, this is not only in America. I want to share with you what CAMP, the Private Commercial Mediation Center, the complex commercial disputes we have done over the last 6 months. We did a family business dispute, more than 1,000 crores worth, a construction contract between 2 international companies, a bankruptcy dispute, 1 company with 16 creditors, a breach of contract dispute between an Indian company, international company, dispute over supply of machinery in a power plant, Indian company and international company, a family dispute in the hospitality sector, and sports dispute with one of the most prominent sports people in the country. These are some of the complex commercial disputes we did over the last 6 months. Settlement, very high. So I don't think I have to argue much more on this topic. I also wanted to give you a long-term perspective. A case that I mediated 10 years ago, it was a family business, a very prominent family of business, and they had filed almost 10 cases against each other, criminal cases. We resolved. The company went on to do very well. Over the past few years, they have been reportedly spoken about in the domestic areas and for their international connections. So a couple of weeks back, I sent a message to the CEO of that company, and I just want to read out his reply to me. Thanks to mediation, we have a chance to do all this good work. I rest my case. From my experience, complex commercial mediation has 2 unique features. One is the parties have a higher degree of desire to resolve. The business of business is business, not litigation. So the parties have a higher degree of desire to resolve. At the same time, there is a higher degree of expectation on efficiency and excellence. This is important. Complex commercial disputes, there is a higher degree of expectation for efficiency and excellence. How do we achieve this in commercial disputes? I'm going to speak about 4 important requirements of excellent, efficient commercial mediation. 1, the need for process design, expertise in process design. Secondly, process skill. Third, mediator's mind. And fourth, advocates who know advocacy in mediation. To me, these are the 4 important requirements of success in complex commercial mediations. So let me go through each one of them. Process design. Process design is primarily about identifying the right people on the table. A mediator who knows commercial mediation can very easily tell you that this is a case where negotiation failed. Parties who are normally experts at negotiation, at communication, this negotiation failed. They need assistance to negotiate. Mediation is assisted negotiation. And this time, the frame has to be different. The earlier negotiation failed. This time, the frame has to be different. So the mediator has to do several things to bring in the right table for negotiation. Identify the stakeholders who can influence that negotiation. Get their commitment. Recently, I did a case where the 2 parties came in for mediation. One side came in, their CEO, their technical team, the lawyers. From the other side, the other company, there was the power of attorney holder for the company, a very influential person in the company. He says that he has complete authority to settle. He has technical experience, he has legal experience. He's been with the company for 35 years. Along with him came the technical experts and the legal experts. I looked at the table. To me, there was something that was missing. All the screens of the technical experts were video not there, can't see them. This power of attorney was the only person who spoke. Everybody else was silent. I knew that this CEO, company A CEO who's there, wants to speak to company B CEO. But the power of attorney holder was not allowing that. He stood like a wall, prevented access. It took me a couple of days to work with this person to gain access to the CEO and bring him to the mediation table. And I cannot tell you how the air on the screen changed. All the technical experts, they came on video, they participated, they interacted, the table was right. That is process design, to know who is missing. You feel it, you can feel it. and bring the right person onto the table. The right documents. You need to bring in the right documents. There was a dispute over property going on for 10 years. Brother A says it's worth 25 crores. Brother B says it's worth 10 crores. The adversarial process only focused on the right and wrong, did not process on the resolution. At mediation, in part of the convening, the mediator asks for a professional evaluation of the property. The moment both parties had an idea what is the real value, resolution became clear. So the way a mediator looks at facts is different to the way an adjudicator looks at facts. The mediator will then model the mediation process according to the needs of the parties, according to the dispute, and a unique mediation structure is designed. So process design is very important for successful commercial mediation, and process design is about having the right parties in the right sequence with the right documents, with the right expectations, right issues, and right knowledge of the consequences if the negotiations fail. That is called process design. So that's important for the success of a commercial mediation. Next, process skill. The mediator needs to possess the skill to help parties have crucial conversations. The parties in dispute must be able to feel I've been able to say 100% of what I want to say, but say it respectfully so that the other person can hear it. That requires special skills, the process skill. And very often, the conflict in the room, the air in the room does not really permit that. This is like the story of the elephant with the three blind men. I'm sure all of you have heard it. Blindfolded, they only saw it in parts. But when the blindfold was removed, they saw this distinct animal elephant. This is what we have to do in mediation. An optimal solution in mediation comes only when the parties have seen the whole picture, have understood everybody's perspectives. And that is the process skill that is required in mediation. In fact, recently I was in a panel discussion with one of the senior partners, Bijal Vakil. He's the senior partner at one of the big IP law firms in the US. And the question was asked to him, what percentage of your cases you mediate? And he said, 100%, 100% of the cases. And he explained, when we mediate that, those 100%, 80% resolve. Remaining 20%, they come out with much more information, much more clarity on their dispute, that the trial is more mindful. So this is what a mediator with process skills can do. Enable crucial conversations. I mediated an IP dispute. Dr. X comes with 3 of his former employees. Infringement, criminal complaints, IP, complex IP, several codes were involved. I asked for an expert to help me understand this, and I was told that the In India, we don't have any expert that understands these codes. So I bring them in. They're not looking at each other when they come in, but over several sessions, we build communication. At the end of a couple of sessions, I was able to bring back the parties to the table. They were comfortable talking to each other. Dr. X was able to explain what are those codes for which non-compete is absolutely important, and what are those codes when non-compete was not so important. He didn't mind the employees taking away those codes. They were able to bifurcate and find a solution. Crucial conversations enable that. So a mediator with process skills can set up these conversations, can provide space for apology, can knows how to maintain confidentiality. Very important for commercial disputes. Trade secrets are involved. So maybe use experts. How do you use experts? It's a very different phenomena, using experts. So this is what a professional commercial mediator will be able to bring in, process skills. The third factor, which is important, is the mediator's mind. What is the mediator's mind? Focused attention. To be able to listen to all the parties, to be able to leave the ego outside, listen without judgment, to be aware that in the room are CEOs, CFOs, important people. They are very good at their work. They are impatient. How do you handle them? How do you connect with each one of them? A mediator has to connect with each party, from the CEO to the technical experts to the financial experts, everybody in the room. A mediator is like a symphony master who connects to each person in the room. Important skill, mediator's mind. And lastly, advocates who understand mediation. Advocacy in mediation is very different to advocacy in litigation. If you bring in the same tenor, same kind of conversations, then you poison the well, which both parties have to drink from. So advocates need to know how to handle advocacy in mediation. They are a very important part of mediation. And they can determine, I get into a room, and when I see the right advocates there, I say, this case will resolve. And on the contrary, I see someone, I say, oh my God, this is going to be a dreadful day. So advocacy in mediation is very important. So these are the 4 important requirements to get the efficiency and excellence in commercial mediation. Process skill expertise, process design expertise, mediator's mind, advocates who understand mediation. And I also want to share with you before I conclude, there is a good positive trend that's happening in our courts. Commercial parties applied for appointment of an arbitrator under Section 11. Some of our judges are referring those cases for try mediation first. If mediation fails, go to the arbitrator. And I'm happy to tell you a large number of them are actually resolving at mediation. So med-arb and arb-med, vice versa, can also happen. This is a very positive trend that is happening in our courts. So to conclude, first-hand experience, complex commercial disputes work very well in mediation. Let's create a pool of mediators with these 4 essential basic requirements of process design, process skill, mediator's mind, advocates who are comfortable with advocacy in mediation. And we can do it. Thank you.
Thank you so much, ma'am, for taking us so comprehensively through the entire process of commercial mediation. Thank you. With this, I invite a second guest of honor, Mr. Tejas Karya, sir, to kindly share his expertise with us. Sir.
Thank you, Ankita. It's my pleasure to speak at this session. I'm grateful to Dr. Ashish Mishra for invitation, and I'm lucky to share the screen with Dr. Rabi, Justice Kothari, Ms. Wallapalli, and my friend Ilam. I'll discuss my experience, and I shared some thoughts about how I have seen mediation helping while doing arbitration, because my focus area of practice for last 20 years has been arbitration. Earlier, we used to think that mediation is alternative to arbitration. But over a period of time, we have realized is the mediation is such a powerful tool that's an integral part of arbitration. And that's where I thought that I'll share some slides which will just make it clear that how mediation and arbitration can go hand in hand. So if we start with the first slide, the short points which I will cover in my limited time available is that what is agreement to mediate? Because unless there is an agreement between the parties, it's very difficult to force parties to mediate, because mediation is purely consensual.
Mr.
And
Tejas,
yes,
we can't see your video. Is there some difficulty, technical issue? Your video is not perhaps on.
Is the slides visible?
The slide is visible.
Slide is visible, but your own face.
Okay.
Yes, now it is
Now
come.
it's visible.
Oh,
It's
okay.
better.
Now
Yes.
it's-
Good.
Thank you. So just to give an overview of my talk.
It's only your picture, but not the live picture. It's only a picture on the screen which is there.
Okay. Is it now better? Yeah. So just to give an overview of the session which I want to make today is that we will discuss about the agreement to mediate and also the mediation in the arbitration proceedings, as I say. What is the statutory and judicial recognition of mediation? The one thing I want to make a very strong case today for institutional mediation, because we have ad hoc mediation happening, but the institutional mediation, and we have great institutions where both the ambassadors of Indian institutes, IIM and CAMP are with us today as part of the panel. And lastly, we can discuss what is the future of commercial mediation in India, because we have seen mediation being used in many avenues. Commercial mediation is something is the future for resolving commercial dispute. So coming to the agreement to mediate, there are a number of institutions which come up with model mediation clauses. That could be a standalone clause to mediate or agreement to mediate maybe after the dispute arises, or a multi-step or multi-tiered dispute resolution in the contract itself. When we have commercial contracts, we have seen a multi-tiered dispute resolution clause where you start with mediation and we go to arbitration if the parties are not able to resolve their dispute. We have also seen hybrid parallel clauses where we have ARB-MED, ARB or MED-ARB, MED, as Ms. Wallapalli just explained. And we have seen great success in achieving the dispute resolution with the help of mediation. And those clauses could be, we have a negotiation, mediation, arbitration, and then in the reverse order, first you do arbitration and then go to mediation. And that has worked beautifully in our experience, is that you start with the one style of dispute resolution, try to reach a particular level and also switch while the one process is going on, and have the mediation come in and try to help parties to come together. And if what we can achieve is a great result. In one matter, hotly contested, the fact was that whether the shares should be transferred, And if so, at what cost? Then parties mediated, and instead of fighting the whole arbitration, they came to conclusion that yes, we will transfer the shares. The only issue which remained is the valuation. So the mediation part was taken care of by the consent award, and the arbitration then took further course with regard to quantification of the amount at which the shares have to be transferred, which reduced the cost to the half. The time and cost came actually half, and that's the advantage of this hybrid process which I'm talking about. The only problem sometimes we face is the delay in the arbitration process because parties take too much of time for resolving and they are not serious with the time frame. So specific time frame for each step helps a lot, because if parties try, one party is always not interested in proceeding with the arbitration and they try to derail the arbitration by going to mediation, that should be avoided. So when they agree for mediation, it has to be done in a systematic way that either you come back to the arbitration or you finish the whole matter in the mediation itself. Sometimes we see that there is a non-compliance with the agreement to mediate. Parties straight away jump to arbitration without even trying for mediation. There are some contrary views of the courts where they say that, look, if the mediation or the good faith negotiation was not possible, given the correspondence and the stand parties have taken, you can bypass the mediation. In my view, that's not the correct view, because at least parties should try and come to a conclusion that they cannot mediate, rather than presuming that there is no need to mediate. And that is where the agreement should be given effect to. And we have also taken a jurisdictional objection under Section 16 of Arbitration Act, that the arbitral tribunal does not have jurisdiction to arbitrate because there was a breach of the contract to mediate first. And we have been successful in sometimes is that parties then are relegated back to the mediation and then decide come back to arbitration. And that was one case where we were successful in doing that and eventually resolved the matter in the mediation itself. So those are the aspects which should be laid out at the time of entering the contract or before entering the mediation, so that the commercial parties have the advantage of mediation, but at the same time, they do not lose the main site of dispute resolution. In the process of arbitration, there is always a window for mediation. It could be at the beginning of the arbitration or in the middle of the arbitration. And we have seen that early mediation has its own advantages, because you can save time and cost in starting the arbitral process. And we have seen that once there are early stage of arbitration where you are just in process of filing the pleadings before the arbitral tribunal, parties realize that they don't have a winning case, or at least they have 50-50 case, and that is the best time to mediate. Even the Arbitration Act puts an obligation on the arbitrator to encourage the settlement and mediation. There are a number of institutions who administer the arbitration. They have specific aspect of mediation, and even in the first hearing itself, there are rules like ICC. They insist that the parties remain present, and the arbitrators at least should offer that whether they would like to settle the dispute by way of a mediation. And if that is agreed, and then they could be referred for mediation under the mediation rule of those institutions. There is always a possibility that a arbitral tribunal can continue with the arbitration, but at the same time set aside some time for the parties to go for mediation. If the procedural timetable has say 1 year of the lifespan, and the whole life of arbitration is going to continue for 1 year, even between the pleadings or before the evidence is filed, the tribunal can definitely ensure that the parties try and explore a possibility of mediator. But then the question comes is whether the arbitrator should act as a mediator. In some jurisdiction, we have issues with regard in commercial matters where the arbitrators can also act as mediator, but in some jurisdiction, there is a serious issue with regard to the fairness of the process, where the arbitrator has a personal communication, one-on-one communication with either of the parties in the absence of the other party. And that can lead to a question of due process. which would then be a issue at the time of either enforcement or setting aside of the award. As far as possible, mediator should be independent than the arbitrator, because arbitrator has to adjudicate where mediator has to facilitate the parties to come to a dispute resolution. Once the mediation is successful, if the arbitration is pending, that helps because that could be a consent award which is enforceable. So the advantage of doing mediation alongside arbitration is that the mediation agreement can be converted into a consent award, which becomes an enforceable award, and it is also recognized under the New York Convention. So even if it is passed outside India or any other jurisdiction, that award becomes internationally enforceable award, even though the outcome of that award is the fruit of the mediation process. That's the advantage of the hybrid process, where you can get the best of the both worlds. There is a statutory and judicial recognition of mediation in India. Under the Commercial Court Act in 2018, we have amended Section 12A, introduced the new provision where we have to have a pre-institution. There are rules which are framed PIMS rules, where the court in commercial matters have to refer the parties to mediation. So apart from arbitration, if there is no arbitration, the parties are going to the court also, then there is a compulsory mediation that is a very encouraging development in last few years. Section 89 was introduced and it was upheld in Salem Bar Association in 2003. AFCON infrastructure in 2010, Supreme Court came to conclusion that in commercial contracts, the mediation is one of the modes of dispute resolution. So we have the judicial recognition also of mediation through judgments of the Supreme Court. In Companies Act, Section 442 also provides for having a panel of mediators for resolving dispute between the parties, and we have seen number of shareholders dispute getting resolved through mediation by reference from NCLT or NCLT, and that is a very good development, because ultimately these are the chunk of commercial disputes which are there, which completely slows down progress, because ultimately it has to be in the interest of the shareholders and public at large. And if you can resolve the deadlock between the shareholders, it can be a great achievement to resolve these commercial disputes. Even in the field of consumer protection, now we have Section 37 and 38 in 2019 Act. There is a mediation which is provided. Recently, Supreme Court also said that there has to be Indian Mediation Act, a special legislation dealing with mediation. So we are moving towards that slowly but steadily, and we should be having a mediation act in near future, because all other jurisdictions, even Sri Lanka has a mediation act, and we don't have it. So we should try and have a special mediation act, very similar to arbitration act we have, to give recognition of statutory recognition of mediation. India is a signatory to UN Convention on Mediation and Singapore Convention. We all were there when it got signed. India signed it. Mr. Lapali was also there. And ultimately, what has paved way is for the role of mediation institutions in India. So, for example, ICC is a leader in promoting mediation. Singapore International Mediation Center has an arbitration protocol with SIAC. I'm on the code of SIAC, but we see number of cases getting referred to SIMC because there is a protocol, and whenever we sit as an arbitrator, we try to refer the matter to the arbitral institution. And of course, there is an advantage of institutional arbitration, because institutional arbitration is more structured than ad hoc arbitration. The institutions play a very important role in providing a guided process for the institution, because you go by the institutional rules which are time tested. There are other institutions like JAM, CEDR, ICDR, IIM, and CAMP. They are doing an excellent job, but the main thing is that the parties should agree to this mediation, or the court should refer the parties to such mediation. The confidentiality is another aspect, because in the mediation, the confidentiality of what was discussed is very important. And these rules ensure that, and it also gives immunity to the mediators who perform as a mediator. There are a number of court annex mediation centers, but those are mainly through the processes where the court refers the parties to the mediation, but purely commercial contracts and commercial disputes. We have seen that number of parties are now adopting institutional mediation, like they go for institutional arbitration or both together, one after the other, one with the other, and that's going to be a future for dispute resolution in India. So when we talk about the future of commercial mediation in India, I feel that there is a greater need for awareness and capacity building for all stakeholders at every level, because mediation is such a great tool that it would really be important for everybody to be trained as a mediator, because I have seen number of cases where the cases get litigated only because there is no proper training about the mediation. And the number of institutions, including Chartered Institute of Arbitrators and CAMP and SIMC, and have the certificate courses on training on mediation. And I've seen in experience that if the parties and the lawyers, basically, if they have intent to settle, 100% we can achieve settlement. It is just the mindset which matters. So ultimately, the training in theory as well as practical is most important, because the mediation is a process, it's an art, and ultimately we have to achieve the success only by dealing with people who are important. As Ms. Olapalli said, that you have to identify the right people, and for that you need training. Ethics is also one aspect which has to be taken into consideration, because the mediator has to have a confidence from both sides, and unless the mediator enjoys that confidence and the standard of ethics is maintained, it would be very difficult for parties to settle the dispute with the help of mediator. Of course, if the matter has to settle by any case, it's fine, but if the mediator has to ensure that it gets settled, mediator plays a very important role, and as well as the counsels who are acting on behalf of the parties, because we have seen many times mediations failing just because one counsel didn't want the matter to get settled. Revamping the institutional infrastructure and uniformity of rules also will help to ensure that the commercial mediation is taken to a next level. Legislative framework, of course, as I said, would really be helpful for having the mediation as sanctity in the international sphere, because India badly needs the legislation on mediation, which is specifically dealing with the mediation aspect. And last and not but the least, but developing a mediation bar, a full-time profession in the mediation, where the mediators act as a full-time, and we have to incentivize the mediators for acting as a mediator. And I remember once Abraham Lincoln said that how the nominal winner is often the real loser in fees, in expenses, and waste of time. As a peacemaker, a lawyer has a superior opportunity of being a good man, and there will still be business enough. It's not necessary that we always litigate or we always arbitrate. Mediation also helps the parties to come together and grow in a commercial relationship, because at the end, what it matters is maintaining a relationship where both parties can make money, and it's a win-win situation. Whereas in arbitration, one party wins and the other party loses. So for lawyers, it is a great opportunity, and we need to really make mediation as a proper process by incentivizing and recognizing the mediator and the process of mediation in the dispute resolution process in India. And I see India has a very bright future in terms of commercial mediation. Thank you.
Thank you, sir, for raising very important issues through your presentation. Thank you. I would now invite Ms. Iram Majid ma'am to share her insights with us and address the gathering. Over to you, ma'am.
So much. Am I audible and visible clearly?
Yes, ma'am. Yes, ma'am.
Okay, thank you so much. So thank you so much for organizing this event during pandemic. And I would like to congratulate the organizers that see, this is the afternoon and weekend, and I can see the strength. So it's the credit goes to the organizers, and I would like to welcome my all co-panelists, Honorable Justice Vineet Kothari, Madam Leela Olapalli, Rajni ma'am, and my dear friend Tejas. So it's been honor to be here at this occasion. So today's topic for discussion revolves around the commercial mediation, and being a practitioner of the same for past 1 decade, with my experience, I have realized that the mediation in practical is one such ADR mechanism, which essentially is able to retain the reason for the evolution of ADR to the next level. So to turn the parties from the conflict and turning that conflict into an opportunity. So today I'll be, focusing majorly on the role of the institutions and from the user's point of view, and also the aspirants who wants to come to join the mediation as their career opportunity, how they can have an edge over everyone. So if we see the benefit of the mediations are multifold, this is what been discussed by the previous two panelists. So like time effectiveness, cost effectiveness, party centered, self-determination, and above all, after the Singapore Convention, the enforcement of settlement agreement is also now it's possible. But even then in commercial relations or the corporate relations, we are not having the relation with the buildings, but we are dealing with the humans, and which is built not in a day, but which has been taken years and years, and for which the corporates having certain value attached to that, and they don't want completely don't terminate it abruptly by way of adjudication. So mediation plays very important role in commercial disputes to resolve, and not only to resolve, but convert into an opportunity. But if we look the statistic is like, suppose, let's take the example of 100 cases. If the 100 cases has been there, 60 will go for the litigation, 30 for arbitration, and 10 for mediation. Why? If there are so much of advantages, and what that we are saying that there's a lot of advantages, and the statistics should have been different. Statistics should be like 60 cases should have been gone for the mediation. So that means the advantages we are talking every day is from the expert's point of view. So we need to understand the user's point of view whenever we are talking about the mediation. So I will be focusing on the user's point of view. So that means the perceived advantages are from the mediation experts. So from the user's point of view, if I'm talking about the dispute resolution process, so what they will be looking at. So once they will be coming for the commercial arbitration and invoking of the commercial arbitration, what would be their first choice and what they will be looking at. So the user's perspective for the dispute resolution process, they will be looking at the consistency in the process, credibility of the process, and the neutral and the enforceability of the result. So for that, the mediator has to be the subject expert. What the Madam Leela Olapalli has mentioned, I completely resonate with that. So the mediator has a subject expert, and he has to expertise for the process as well. So when I'm saying subject expert, I mean the mediator who is having expertise in negotiation and mediation skills. But for the mediator to use his subject expertise, he should use his process expertise before that. So where he should be able to keep the parties before him to sit at least for an hour and to gain the confidence of the party as soon as possible. So the expertise in the skills is more important as we are talking about the expertise in the subject, because parties will not be able to sit for an hour where you will be talking about other things. So for the first and foremost thing is you need to know how to make sit the parties in the room. And otherwise, when you will be using the attempt, or you will be before you attempt to use your mediation techniques, the party may walk out and resulting into the failure of mediation. And for this, the mediator should have multiple process skills, which could include knowledge, neuro-linguistic science, neuro-linguistic skills, body language, cross-culture or cross-border culture differences, psychology, hypnotic dialogue techniques, and neuroscience, and many more. The mediator will have to understand the psyche of the party sitting before him and understand how the brain hormones of the parties can be triggered so they can continue to sit before him, by which time the hypnotic language you can use, and you can ease their perception, and you can control over the situation where you can start using your mediation techniques. And for this, we need to transform the mediation from an amateur or the casual dispute resolution mechanism to a professional and a specialized process. We need to add glamour to it. And we have to bring certain benchmark in the process and the procedure of the mediation. And so that the parties could be familiar how mediation happens, irrespective of which mediators they are going to or which country it is happening. So this is where the emphasis has been drawn on the two important aspects. One is accreditations, and the other is institutional backup. So when I'm talking about the accreditations of the mediator, it's not only give the credibility to the mediators that they have a certain international benchmark of the quality, but give the confidence to the users to select them, as it is an assurance to that the mediator has the required qualification, knowledge, and the experience, and the impartiality and neutrality expected to him. And above all, the mediator should be under the professional code of conduct. That was Mr. Tejas has, recently he mentioned about the professional code of conduct. So that is something which is most important. So it's from the mediator sides I'm talking about. Suppose if when we are looking at the accreditation, we need to see the quality of accreditation process and how it helps to broaden your career. If suppose you want to make your career into mediation, because it's not a domestic or the domestic profession now, it liberates all the jurisdiction. So it's a global practice. So if you want to broaden your career even, so because the commercial mediation, it's the global area. So you need to have an accreditation. That is must. You cannot say that I don't want to have accreditation, but I am having an expertise in it. So no, accreditation, you cannot afford not to have the accreditation, because after that, no one can doubt your skills and knowledge. So, and one thing is most important, that it is a wrong notion that the parties are not aware about accreditations and all before selecting the mediator. See, I received a call from the GC, General Counsel of a corporate business group, saying that we have a case pending in India, and the mediation is scheduled in Hong Kong. So we want a mediation lawyer. But our lawyer is not, he is a litigation expert. So we don't want him to be in mediation. So can you be there? So see, this is how you should know that by accreditations, the people will be reaching you and they will be selecting you. From the user's point of view, it is very important that you possess certain qualifications and certain benchmark. Even I have been appointed by ICC Paris in one mediation, and that was also based on my accreditations, because that will be giving an edge over others commercial, in disputes. So here I have to mention about because we are talking about the accreditation. So I'm talking about the APCAM accreditations, which is provided by the Asia Pacific Center for Arbitration and Mediation, and which is having the center in India, Australia, Malaysia, Hong Kong, Thailand, Indonesia, South Korea, and Nepal. China, Japan, Mauritius, and Taiwan will be joining shortly. And APCAM is not only giving the accreditation under the stringent quality measures, also guarantees impanelment in about 10 countries, which is for the very first time in the history of ADR. And that expanding the horizon of your practice in more than 10 jurisdictions. And there are many accreditation bodies which just accredit you, but no empanelment. And there are institutions which empanels you, but no accreditations. But APCAM is the only institution in the world right now which gives accreditation as well as empanelment in different jurisdictions under the same QAP with the same listing fee. So now coming to the second thing, like what the users will be looking at, they will be looking at the consistency in the mediation process. And herein the role of institution is very, very important. The institution is just assist the parties and the mediator to navigate the mediation process professionally by giving them the effective, if they are having the effective clauses, hybrid mechanism, good admin help, and online guidelines. but also provide innovative rules and procedure will help them to resolve their dispute more effectively. For example, like let's take an example, like we are having a rule for mediation, like unique feature is the project mediation. So the project mediation is on the emergency mediation. This is something which helps the parties to effectively manage or resolve their disputes. So by project mediation, the parties appoint the mediator at the commencement of a contract, and the project mediator oversees the project during the contract period, and that no major disputes happen in, and if any dispute happen during that time, they are managed simultaneously. So the project execution is not hindered. And similarly, we talk about the emergency mediation. So emergency mediation, the dispute is sought to be resolved urgently within a time frame of 7 days. These are the innovations by the institutions, beside providing good rules, good admin support, good neutrals, good empanelment, good accreditations, but it enhances the use of commercial mediation and add more glamour to it. It will be adding more professionalism towards it. And see, the parties can be confident that the procedural aspect of the mediation and the primary process, the mediation is consistent throughout the all jurisdiction. And whichever accredited mediators or like the mediator will be mediating, the style will be same. The style will not vary, because if you will be going to a different jurisdiction, there will be a different style the different mediators will be following. So, but if you will be sticking to a procedure or to the rules of the institution, they will be providing you the consistent procedure, and that is very, very important from the user's perspective, because that will, give the confidence regarding the process. Because it is being said that many times that the parties will be going to one mediator, they will be doing in a different style with a different process. So that will, because it will be hindering the process. It will be like giving a confusion in the mind that this person under that rules, it will be done like that, but this person is doing into that manner. So that is why we are trying to bring the uniformity, and that is must for the commercial disputes. Because why arbitration is very common, why our parties are choosing arbitration, because arbitration is done under the act, and the same process are there. But for the mediation, we don't have that, and the parties are looking at that. So from the parties' point of view, and we have to maintain that. And see, one thing I would like to add, because I see the time is not there, but the responsibility is equally upon everyone. It is not the only responsibility of the mediator. It's not the only responsibility of the lawyer. It's not the responsibility of the institution, but users as well. So all the four limbs for the mediation has to join together and work as a cluster, in a single unit. And only we can see the mediation, because mediation is the future. But the only thing is, statistic wise, we can see that it is not coming up so well, because maybe the users may not have that confidence. And for bringing the users into the confidence, we have to create that kind of ambience first. So this is what I would like to talk. And lastly, I would like to say the way forward. So what is the way forward? We need more institution with innovative mechanism to make India as a hub for mediation. See, after arbitration, after Singapore, New York Convention, even so far, we are fighting for the India for making the hub as an arbitration hub. So if we will not take care professionally, and we will not attach credibility to this profession, we will miss again. So before missing again, we need to take care from the all corners. And the way forward is, again, I would like to use one phrase, that catch them young. See, the lawyers are the hurdle and the lawyers are the hope. So I feel that we should train more youngsters or the young generation as a mediation advocate, so that we can have a culture of mediation. And there should be, because they are the hurdle and they are the hope. So catch them young and train them into the mediation advocate, so that we can have a complete full table game with all the team and all the people in their own respective roles. And the lastly, I would like to say the last way forward, and this is the most effective one, we need to have more women experts into it. We need to have more women into area. And I am so happy to see the panel today that me, Rajni ma'am and Leila ma'am, the three women are sitting over there and the males are in the minority. So it gives me, I was seeing this for the very first time I see that the females are, in majority in a panel. So this is the future, and women experts into ADR, we need you, and we need them to be in making it a strong institution. So this is all from my side. Thank you very much. And with this, I have to end my address, and I would conclude by saying that to make an end is to pave the way for a new beginning. And therefore, I am hopeful that such discussion will lead to the beginning of much required changes in the practice of mediation in India, which will eventually help in adopting as well as adapting to the needs of stakeholders, just leading to the new beginning or India becoming a global center for commercial arbitration, mediation, sorry. And wish you all the best, everyone, and stay safe and stay healthy. Thank you so much.
Thank you, ma'am, for educating us about the perspective of the parties and sharing your very valuable insights. I would now like to invite our chair, Honorable Dr. Justice Vineet Kothari, to share his extensive knowledge and further enrich the discussion on this topic. Your Lordship.
Thank you, ma'am. And first of all, I should thank the organizers for giving me this opportunity to speak my thoughts on this occasion with the panel of experts. I'm visible and audible. Good. The theme of the entire conference, which you people are organizing, is Capacity Development Program and Innovative Practices in the Fields of Mediation. Well, friends, mediation is rightly said by Iram Madam, that is the future of the ADR system in this country and worldwide also. And this is the subject I am also in love with, because as a sitting judge also in Madras High Court, I organized a training of as mediator conducted by MCPC of 26 judges. I was one of them. So I am also trained mediator now. And I know that this process which results in of litigation in our country, where the tiers of the appeals and revisions are so many that one doesn't get out of it very easily. So mediation is here to stay. But till we have the new comprehensive mediation law as directed and suggested by the Honorable Supreme Court in 2019 judgment, as pointed out by Mr. Tejas Karia, we are yet to have that law. Of course, last 20 months have been washed away in COVID period, and nobody has any other business except to look for the corona and treat himself or herself from that. The parliament doesn't have the time, the government doesn't have the time to look into these rather second priority items. Commercial disputes and commercial fees, litigation is a costly affair, is a very long affair. Therefore, nobody really wants to go for it, and therefore mediation has to be taken very seriously in this field now. I have some experience of international taxation also, because as introduced, I have been going there for conferences. So even the international treaty disputes are now sought to be resolved through procedure. That is nothing but a mediation only. So at all levels in the economics, commerce, and taxation fields, also will need mediation as a ADR system, or the most effective system, I would say, in the judicial dispensation of our country. Of course, the enactment of the Commercial Courts Act in 2015 and major amendments of 2018 have given you a jump from 130th position in 2017 to 63rd position in 2020 in the ease of doing business, which is one of the topics in this conference also, I know. But there are some issues with commercial courts. So you can't just wish away the problems which are there in this field also. As somebody said, that if you have 10 problems and you ignore them, 9 will go away. So the 9 problems may go away elsewhere, but in the real concrete things to be done in this area, we not only need a comprehensive law in place, but we rightly said by Madam that institutional mediation should be recognized, properly done, and it should be publicized so much properly that people fall for it, go for it, and use it as consumers of justice. I'm very conscious. We are generally viewing mediation only as advocates doing court and ex mediation. No, this is not the correct thing to do. We need all experts of all fields, like chartered accountants, company secretaries, engineers, in the field of mediation. They should be given due recognition. They should be entitled to work as mediator, because people will go to experts with the faith and belief that here is a person who can guide us through. In commercial disputes, already big corporates or big companies, taxation disputes, they are already guided by experts. So they need mediators who are, if not more, at the same level, at least expert of the same and having independence in the matter. So that mediation cannot be forced, as we all know. Mediation is a voluntary thing. Discuss, guide, and bring the people to the negotiation table, mediation table, and then guide them through up to a mediated settlement. You may try arm and mag, nag and mag, whatever. Develop to take place. So all these things can take place only if mediation. Now, Afcon Industries case, Afcon Construction case, Section 89, scope that is explained by Honorable Supreme Court in later judgment also, are things of the past. Let us have a need of day. As far as Commercial Courts Act is concerned, friends, despite Section 12A introduced in the Act by 2018 amendment, which says that pre-institution of the case, you will have to go for the mediation. But that amendment also, I would like to give my comment or rather suggestion, has one problem in it. That says that if the parties insist for an interim relief in the matter, they ask for a stay, they need not go under Section 12 capital A to the mediation first. They can approach the court directly, commercial courts as defined in the Act, within our 3 lakhs limit set in that law now. Any case having 3 lakhs or more value. Now there, the pre-institution mediation which was mandated by Section 12A has been given an exception. And that exception is that if you ask for an interim relief, you can first go to the court, settle the thing, and then go to the mediation. Now, in my humble understanding or opinion, the provision should have been otherwise. The provision should have been to grant an automatic stay or automatic status quo of the disputants before the mediation is tried out. If you allow parties to go to court first, the very purpose of mediation is defeated. So with the time period of 3 months or 6 months as given in the law, there should have been an automatic stay of the parties not changing their status so as to cause further prejudice to the other party, so long as the mediation is properly tried out. That only would have encouraged the mediation in the proper sense in Commercial Courts Act. Another thing which I want to emphasize with reference to these Commercial Courts Act through this platform, which is very important, I understand, because it is an international conference and your inputs will possibly reach a point where people who have to do something about this now system are manned by people who are general district judges or senior civil division judges. Now they cannot be expected to be experts of all the commercial laws. There are so many commercial laws in our country and elsewhere also. So to put an end to this commercial disputes in the courts, commercial courts as now enacted by India, we should have a separate dedicated cadre of district judges or even civil judges where the recruitment should be open to experts of the fields which I have just now told you, like chartered accountants, ex-advocates. All these people can really man those special commercial courts. Then only they can possibly deal with the disputes arising in various new economics laws like bankruptcy law, taxation disputes, commercial laws, which are so many. Take, for example, Section 138 cases. There are thousands and lakhs under Section 138. Now, this is the area which could be dealt with by these courts through mediation. We have been trying. I was in charge of mediation at least 4 high courts. All the 4, Rajasthan, Karnataka, Madras, and now Gujarat. But the thing is, we do not have the property to go for mediation in these disputes. And therefore, there is an urgent need, I would say, to man these courts with specialist people. Third aspect I would like to emphasize, and most of you who are in students also in your university, is an urgent need again to incorporate mediation as a comprehensive subject in your graduation level. I do not know whether your 5 years courses as of now or 3 year courses as of now have this course or not. But there is an urgent need to train these young boys and girls at this level itself. Because when they become professionals, they are ready to be further trained if necessary. Otherwise, they are already qualified to enter this field. And rightly told by Mr. Taria, there should be a separate dedicated bar of mediators. It's a high time where mediation is taken as a specialist subject. And therefore, a dedicated bar with due recognition, with due incentives given to them should be provided for either in the new law or otherwise. I do not think MCPC alone can undertake this entire business. There has to be a need to broad base this education and this system as a whole. Now, before I wrap up, just one more point I would like to make. In the Commercial Court Act itself, I was looking into this act recently for addressing another webinar of this nature. I came through a Supreme Court decision in Ambalal Sarabhai's case. Of course, Supreme Court Judge said that commercial courts are open for one of the categories which defines commercial disputes is like this, that where immovable property is actually used for commercial purposes, the disputes pertaining to that property, immovable property, can go to commercial courts. Now the Honorable Supreme Court said that merely because there is a possibility of such a building or a immovable property to be used in future for commercial purposes will not put it within the realm and jurisdiction of the commercial courts, and therefore it will remain in normal civil courts jurisdiction, is the judgment of the Honorable Supreme Court. With greatest respects, I would say the Honorable Supreme Court itself said in that judgment that since there is no particular stipulation in the contract about the commercial use of the building, therefore we are holding this view. But that judgment, unless analyzed properly, is likely to tell you in the first impression that matters pertaining to immovable property which are not commercial property as such will not be going to commercial courts. This, in my respectful submission, is incorrect interpretation. Because take an example, somebody is constructing a mall and halfway through there is a dispute between contractor and the company who gave this contract of construction. Matter is to be taken to commercial court. Mediation fails. Where to go? As per this judgment, we have to go to civil court, where the entire purpose of this commercial court's business will be defeated. This was done to expedite the process, dedicated courts. Now, therefore, and the words actually used in the definition clause itself has to be interpreted, in my humble opinion, as possible future use also. Now, it's a matter of debate. Now, therefore, these legal interpretations apart, we are presently discussing the mediation as a unless we have sufficient experts, number of experts in all the states, rather all the districts, I would say, go to the extent of saying that, because commercial disputes is basically what? Lex mercanda, law relating to unless you have mediators, state mediators, expert at all levels, probably you will only be talking in theory. That mediation is very good. To become it effective and possible at all levels, we need experts. So, you have said, you have triggered the debate, you have called experts who have given their expert opinion from their practical experiences. I can see 3 of them very nicely because I know at least 2 of them very well, Mr. Karia and Madam Leila Olapalli. Madam Miram has perhaps not appeared in conference where I was also a party, but now today is the first one. Happy to hear you, Madam, also. And these are my views which, taken in a comprehension, we are in a progress path. We have to do a lot in the field of mediation, but definitely this is going to be the target which will be worth achieving and worth putting in place properly as a parallel, as an effective parallel to mediation in the country. Thank you so much for giving this opportunity to speak to you. Thank you so much.
Thank you, Your Lordship. It's an absolute honor to have you with us today. With this, we reach the end of this session. The insights shared by the panelists have been deeply rewarding and informative. It has made this session a great learning experience for us all. May I again invite our co-chair, Professor Dr. Rajni Abhi ma'am, to present the vote of thanks. Ma'am.
Presenting a vote of thanks to such an august gathering, I think it's a very difficult thing because all the suggestions which all the panelists have given, this all will be compiled and it will be sent to Samadhan, where I think they will use these suggestions and introduce changes which all of you have suggested. First of all, I would take this opportunity to thank Ms. Leila Olapalli for sparing her time for this conference. I know these times are very difficult. The pandemic is there. And this is one of the reasons why we had this virtual conference, because it is difficult to hold a physical conference in these difficult times. Ma'am, your suggestions in complex commercial mediations, that there is a party's desire to resolve and there is a higher degree of expectation for efficiency and excellence. They're very well taken. And all the essentials, the 4 essentials which you pointed out, need for process design, need for process skill, the mediator's mind, and advocacy in mediation. The mediator must have a focused attention to resolve all these things. And this kind of advocacy is different from advocacy in litigation. And these are very well taken. Thank you, ma'am, so much for your insights. And I think all the students and all the participants who are attending this conference will definitely take help from it. Next, I would like to thank Mr. Tejas Karia. I know you're a very busy person, but sparing time for this conference, it was very good of you, and it would be very helpful. You pointed out that mediation now is an integral part of arbitration also. Nowadays, the process has become so hybrid that it can start with arbitration, in between there can be mediation, then again arbitration. But the best part is in mediation is if you differentiate it from arbitration, is that in arbitration you have an award which may not be liked by either party, but in mediation you have consent award which is to the liking of both the parties. You discuss the whole topic in 5 things: the agreement to mediate, the use of mediation in arbitration proceedings, the statutory and judicial recognition of mediation, institutional mediation, and future of mediation in India. I think the future of mediation in India is really great. All the acts which you discussed, the Commercial Courts Act 2015 as amended in 2018, the CPC Section 1889 read with Order 10 Rule 1, the Companies Act Section 442, the Consumer Protection Act. Let me tell you, I teach Companies Act and Consumer Protection Act to LLM students, and they also find it very fascinating. Now, the Consumer Protection Act has also included this, and we are very hopeful that all the district forums and the National Commission and the state commissions will have these mediation cells also, because it always is not necessary that all the matters have to be decided upon by the judges. Many of those can be solved in a very easy manner in mediation. So thank you, sir, for sparing your time and your valuable insights. Next, I would like to thank Ms. Iram Majid. It seems you're very busy in a lot of international arbitrations, but we have what do you say, stolen some time from you, and we're really grateful for it. You've been practicing mediation for a decade, and we took the advantage of your practice and your experience, and you told us the benefits of mediation. There's the time, we save cost, etc. And mediation also not only gives an opportunity to resolve the matter, but to build relations also. This was a very beautiful point which I found. And the user's point of view, because the qualifications of mediators, etc., we all discussed, but the user's point of view you discussed, and that was a very good thing, that the mediator must be a subject expert. He must have skills in mediation, and for that, accreditation and empanelment of mediators is definitely necessary. And we really hope we take these suggestions from you, because we are running a legal education course. And as such, we can train a lot of young minds for these skills for mediation. Last but not the least, I have to thank our chairperson, Honorable Justice Dr. Vineet Kothari. He must be very busy, and he is spared the time, and he has given our consent to be the chairperson of this session also. Sir, till we have a comprehensive mediation law, I agree with you. This past 1.5 years, we have really lost in the pandemic, and lost in the sense that to the extent, today, if you see, the High Court, Delhi High Court had to pass an order even for the supply of oxygen to hospitals. If that is the work, if the High Courts have to do, we can imagine how much of time we have really lost in this pandemic, and the energies which we have lost. You're absolutely right that this has to be taken seriously, because the ordinary litigation is quite costly and dilatory also. Even in taxation matters, which you're an expert on. And you said that institutional mediation must not only be there, but it must be well advertised also, so that people know about it. And we must have experts in all fields, because in this session, we're talking about commercial mediation. So people like chartered accountants, cost accountants, they must be there. And there must be a separate cadre of judges and bar also, as you suggested. So let me tell you and inform you that in our legal course also, we have a paper on ADR, or alternate dispute resolution. And we are now training students in arbitration also and in mediation also. But all of your suggestions, all the panelists, they will go a long way for our students also, and for our faculty also, because our faculty also is new to these kinds of things. So we need new ideas, how to train our students also. I'm indeed grateful to all the panelists. Thank you very much. And last but not the least, I would like to thank Dr. Ashutosh Mishra, Dr. Ajay Sonwar, Dr. Ashutosh Acharya for organizing all this seminar and doing it in a very nice manner. Thank you, all of you. Thank you so much.
Thank you, ma'am. I again thank all of you for joining us today and making this session a huge success. It is requested of all the participants to kindly fill the feedback form that is provided in the chat box. Also, the same link would be active for a valedictory session to be provided now. With this, the session comes to an end. I wish everyone a great day ahead. Stay safe. Thank you.
Thank you.